Thank you for joining us for this quarter's Compliance Bootcamp webinar, Consumer-Driven Healthcare Explored. All participants will be emailed the presentation slides by tomorrow. At the bottom of your screen, you'll see several widgets for your use during the presentation. For example, if you have a question, please click the purple Q&A icon to the left. At the end of the session, the yellow certification icon on the right will become active for you to download your SHRM and HRCI credits. Speaking today is Dan Cooperstein, Senior Vice President of Compliance at Corporate Synergies. Corporate Synergies is a national insurance and employee benefits brokerage and consultancy where Dan is a respected thought leader on healthcare reform. He has published many articles and videos on the Affordable Care Act and other laws and regulations which can be found in the Knowledge Center at corpsyn.com. Dan is an ERISA attorney with experience in a broad array of sophisticated employee benefits and labor and employment matters, including the ACA, COBRA, HIPAA, and GINA compliance. At this time, I will turn it over to Dan.
Great. Thanks, Ashley, and welcome to our presentation today about consumer-driven healthcare. We're going to start out today focusing on recent changes in the law and regulatory world that apply to consumer-driven healthcare plans, including some new provisions that are in the American Health Care Act, or the bill commonly referred to as the Trump Care Bill. We're going to talk a little bit about that and how that might be affecting your plans if that goes into law. And then we're going to really focus in on we're going to have a refresher. We're going to do a big refresher on the main basic requirements of consumer-driven healthcare plans. So we're going to go into HRAs, FSAs, HSAs, talk about common issues that we see here in our compliance consulting division, issues that come up with our clients that are common issues, and we'll talk about that. And then we're going to give some key takeaways that employers and plan sponsors can use to help embrace consumerism while at the same time stay in compliance with all of the rules. And then finally, we'll close out the presentation today by talking about some recent healthcare-related compliance developments that are important for your plans, including a really important Supreme Court decision that happened recently. So, with all that being said, let's go ahead and get started. And there's really no other way to begin a presentation like this without talking about what's called the mobile or contingent workforce. And generally, that refers to employees who are independent contractors, temp workers, self-employed workers, or work pursuant to other contingent or alternative work arrangements. And the number of employees in that area is growing rapidly. Recent studies have shown that it's expected to be approximately between a third to a little under a half of the employed workforce in the United States is engaged in at least some kind of contingent work, whether that's something like driving an Uber car, or something more traditionally considered to be temp work. It's a growing part of our economy. So Congress, especially this new Congress that we have, is really focused on trying to make health plans more accessible and more portable to this growing segment of the workforce. So it's important to kind of understand that backdrop before we go forward. And of course, I think that picture on the top left is great because when you think about millennial workers and all the studies that come out about millennials in the workplace, they're considered to be much more mobile in today's economy and much more open to health plans and things like HSAs, things that they can take with them. And that's essential to consumer-driven healthcare. So let's just focus in on some of these. We're going to go through these developments that have happened in relatively recent developments affecting consumer-driven health plans and talk a little bit about them now as sort of a big picture look, and then we're going to focus in on a few of them that have a bigger impact on employers. So first of all, back in May of 2015, House Representative Tom Price, who's now the Secretary of the Department of Health and Human Services, introduced the Empowering Patients First Act, which would greatly expand consumer-driven healthcare in many ways, but especially when it comes to health savings accounts, or HSAs. So we're going to focus a little bit on that in just a little bit here, zoom in a little bit on that later. But then in June of 2016, we saw another big thing happen, which was that Paul Ryan, now Speaker Paul Ryan, introduced A Better Way, our vision for a more confident America, which is generally generally referred to as his ACA replacement plan, but it was a much bigger vision than just an ACA replacement plan. It came out with a lot of other really interesting proposals to fix problems that he saw in U.S. healthcare policy. So the big thing there is that really had that proposal, A Better Way, had a real big impact on what we saw in the American Health Care Act, or the Trump Care Bill, that's currently being considered by the Senate, under revision by the Senate. And there was something else that was very interesting in there. There was a proposal in there proposing to change the rules about small business HRAs. He wanted to make HRAs more flexible, and we saw later in the 21st Century Cures Act, which was signed by the president, that became a reality even before by President Obama, even before the Trump administration. So we'll talk about that in more detail in a little bit as well. Also, something that happened in late 2016, then candidate Donald Trump, who's now obviously President Donald Trump, released a campaign website proposing a significant expansion for health savings accounts, or HSAs. One of the more interesting rules that he came up with on his campaign website was to allow families to pass on the money in their HSA funds to other individuals in their estate. And that was something that had never really been allowed before. It was allowed for, currently a spouse can inherit HSA funds without any kind of tax, but he wanted to propose eliminating the estate tax penalty for any kind of HSA transfer to the family. So that would be a big change to the way HSA funds work. That proposal that he came up with on his campaign website actually did not make its way into the American Health Care Act, but it was a very interesting idea. And then, of course, like I just mentioned, December 13th of 2016, President Obama signed the 21st Century Cures Act into law, which incorporated that proposal in Paul Ryan's A Better Way to create this more flexible new HRA for small employers. And that new proposal was called the QSERA, the Qualified Small Employer HRA. And we'll be talking about that in just a little bit and looking at those requirements. And then in early 2017, we saw just a wealth of proposals come out, just a big treasure trove of proposals from Republican congressmen to repeal and replace the Affordable Care Act. But in those proposals, there were some very interesting ideas about consumer-driven health plans. And it's our view and the view of many other legal commentators that those proposals could still make their way into law, even if they didn't make their way into the American Health Care Act, which was in some ways limited because of the budget reconciliation process. These things could still become law through other legislation. So, for example, in the Bill Cassidy plan, for example, he had a provision in there that would allow for HSA contributions to be used for paying for insurance premiums. In the Orrin Hatch plan, which is the Patient Choice Affordability, Responsibility, and Empowerment Act, there was an interesting proposal in there to enable spousal catch-up contributions to a single HSA, as well as a proposal to allow for over-the-counter medications to become eligible HSA expenses. And we did see both of those make their way into the American Health Care Act. And one of the most interesting and unique proposals was in the Rand Paul proposal, his Obamacare Replacement Act bill, which would allow for unlimited contributions to HSA, so you could save as much as you want tax-free in your HSA. And whether or not that's a viable option or not, it's definitely one of the most creative ideas that we've seen. And then in January through May of 2017, we saw the new Treasury under the leadership of Secretary Steve Mnuchin really focus in. The IRS really kind of focused in on consumer-driven health care plans, as well as cafeteria plans, which are the vehicle for a lot of the consumer-driven health plans. So coming out with a lot of new guidance. A lot of it was more in the way of clarification. One interesting rule came out. One really interesting piece of guidance came out, which was an unofficial IRS guidance that was released on January 20th of 2017. It was a Chief Counsel Advice Memorandum, 2017-0313. And it was very interesting for cafeteria plans and fixed indemnity plans. It said that the IRS would in the CCAM, it said that the IRS would consider a fixed indemnity health plan that is employer paid or purchased by employees on a pre-tax basis through a cafeteria plan. They will consider that as resulting in taxable income equal to the amount of any of those reimbursement benefits that are paid out under the plan. And the reason for that is because and so essentially now, what you would have to do then is, of course, you'd have to pay for those fixed indemnity health plans on a post-tax basis. In other words, take them out of the cafeteria plan. And the reasoning for that is that, that when a fixed indemnity health plan is employer paid or purchased on a pre-tax basis, the usual tax-free treatment of the benefits paid under Code Section 105 are not available because the amount paid is not considered to be a reimbursement of medical care under Code Section 213D. So in plain English, that essentially just means that we don't consider fixed indemnity plans to be normal reimbursement arrangements. They have to be paid on a post-tax basis. So that's kind of a big change that we've seen recently. And then on May 4th, 2017, obviously that was a very big day for our government. The House passed the American Health Care Act, which was that proposed ACA replacement bill, and that would expand the flexibilities of HSAs and health FSAs, and we're going to go into some more detail on those rules that were in the AHCA. And then on May 24th of 2017, we saw a very interesting bill come out, this new bill that was called the Portable Benefits for Independent Workers Pilot Program Act, and this bill would authorize a total of $20 million for competitive grants to states, local governments, and nonprofits for pilot projects to design, implement, and evaluate new models or assess and improve existing benefit programs that allow workers to maintain benefits when changing jobs. And the focus here for the DOL is to prioritize models that can work at the national level and that would encompass a variety of portable benefits, not just healthcare benefits, but also retirement and pension savings, workers' comp, income security, disability coverage. So it'll be very interesting to see what comes out of that proposal, and we're all watching that very closely. So let's focus in now a little bit on these new CUSERAs, these qualified small employer HRAs. Even though the vast majority of our clients here at Corporate Synergies have more than 50 full-time employees, this is still a question we get quite often about how to use these things and what the requirements are. And I guess I just said the first requirement, which is that you can only use a CUSERA if you have less than 50 or more full-time employees, including full-time equivalents, and you're considered to be an applicable large employer under the Affordable Care Act. So this is really for those smaller employers out there. It's a real special benefit. And just to kind of give you a little bit of background here, just so you kind of understand why this is so important and such a big development, and that is that the issue is that prior to this, prior to the ACA, many employers, especially small employers, would reimburse the individual premiums of their employees, whether they were purchased on the individual market or whether they were purchased on an exchange. During the ACA, they essentially outlawed this. HRAs had to be integrated with a major medical plan, and they were prohibited from reimbursing individual premiums, either in the individual market or the exchanges. So Paul Ryan, of course, came along in his proposal A Better Way and said, hey, let's bring this back. And he brought back the idea of this CUSERA, saying let's make this legal again because it's more flexible for smaller employers. So that's how we got to where we are. So just to go back to those requirements, again, the first requirement, 50 or more full-time employees, including full-time equivalents. Second requirement, you cannot be sponsoring a group health plan. So if you sponsor another major medical plan, for example, then you don't have the right to take advantage of these rules for CUSERAs. Additionally, the CUSERA arrangement cannot reimburse in excess of $4,950 for individuals that's indexed annually for inflation, or $10,000 for family coverage, also indexed for inflation. And you can only reimburse Code Section 213D medical expenses. So it has to be something that's medical, but it could be anything. It could be premiums. It could also individual premiums, but it could also be for other medical expenses that employees have. There is also an annual notice requirement for CUSERAs, And originally, when as written, the notice requirement required generally 90 days notice before the plan year. You had to give this notice and say that there were some other requirements as well. For example, the notice had to include a statement of the amount that would be the eligible employee's permitted benefit under the CUSERA. But in IRS Notice 2017-20, the IRS said you don't have to comply with this until 90 days after the IRS issues guidance on what's going to be in the notice's content. So that was some good news for employers that are trying to adopt one of these plans. And the other thing, too, is that there are some other additional ACA premium tax credit coordination rules that apply. Generally speaking, if the employee is entitled to a premium tax credit from an ACA exchange, the CUSERA benefit will reduce that credit, so it's just something to take into account. But of course, the great thing is, is that this just offers a lot more flexibility for small employers wanting to adopt these plans. You can adopt them anytime after January 1, on or after January 1 of 2017. Some of the key takeaways here for employers, like common questions that come up are, what can and cannot be reimbursed, and generally speaking, anything that's medical care under 213D is an expense that can be permitted, but out-of-pocket expenses that are already reimbursed from another source, as well as premiums that are paid for on a pre-tax basis would not be, for example, through a spouse's employer. That type of stuff would not be allowed. Can an employer restrict the eligible expenses that can be reimbursed under a CUSERA? That's another common question. There's nothing in the statute that expressly prohibits that, so presumably you'd be allowed to do that, and that is allowed, generally speaking, with HRAs, so there shouldn't be any problem with limiting what kinds of eligible expenses can be reimbursed. Another question is can an employer also offer an HSA contribution arrangement in addition to offering a CUSERA? And also, again, this is another situation where it's not expressly stated in the statute, but there's no reason to assume you would not be able to do that, especially since, especially if the employer offered reimbursement for high deductible health plan coverage. So in other words, you would have to be enrolled in that high deductible health plan prior to getting the HSA, which is one of the rules we'll talk about later. And assuming, of course, there was no group health plan offered, and the CUSERA itself would not be considered a group health plan. So there shouldn't be any reason why you would not be able to do those two together. We'll see if there's going to be any subsequent regulations or guidance on that, but at this point in time, you should be able to do both of those things together. Okay, so let's talk about what's happening, what some of these proposals are, right? These Republican proposals. We just wanted to focus in a little bit on this one and the American Health Care Act. This first one, because it was the Empowering Patients First Act of 2015, we're going to focus on it because it was proposed by Tom Price, who is now the Secretary of the Department of Health and Human Services, and given that important role that he has in enforcing the Affordable Care Act and healthcare policy in this country generally, it's always really good to look at what he's proposing and what is important to him. And if you look at what he proposed back in 2015, it was very interesting. He proposed that we relabel high-deductible health plans as HSA qualified health plans, just to show you how much he really loves HSAs. He wants to just rename high-deductible health plans altogether. And then he wants to increase the allowable HSA contribution to be equal to the maximum IRA contribution level. So that would be $5,500 for 2017. So that would be a huge increase. He wanted to allow for a $1,000 one-time HSA government contribution to encourage people to enroll in HSAs. He wanted to provide a refundable tax credit for health insurance, which, as you probably know, if you've been watching our webinars and seminars, that part got made it in to the American Health Care Act as part of the Trump Care bill. That part made it in. And by the way, when we refer to Trump Care, just as a disclaimer, we are not in any way saying that in a derogatory sense, or we don't take any political position. It's just an easier way to refer to it rather than me saying AHCA over and over and over again. So that part made it in, and as part of this proposal, he wanted to say that if the premiums are less than the tax credit amount, then the remainder could be deposited into the HSA. So it's a very interesting concept there. He also wanted there to be He said that if you have a required minimum distribution from a retirement plan, that you could transfer that to an HSA and without it being included in your gross taxable income. He also wanted to enable employers to roll funds over from FSAs, HRAs into their HSAs in a future year, so that would make things much more flexible. He also wanted to prohibit HSA funds from seizure in the event of bankruptcy and allow spouses to make up contributions to the same HSA account, which was also something that last part was included in the Trump Care bill. Okay, lots of stuff. There's still more. A few other things that were in this plan. He wanted to expand the availability of HSAs by allowing Medicare Part A enrollees, veterans with service-related disabilities, Native Americans utilizing HIS or tribal medical services, TRICARE Extra or TRICARE Standard enrollees, all of those people, he wanted them to be able to utilize HSAs. He also wanted to increase the spectrum of HSA-eligible expenses, allowing for prepaid physician fees, including payments for concierge care medicine, and periodic fees paid to medical practitioners, as well as he wanted to allow for over-the-counter medication if it was part of preventive medication designed to address complications that could result from chronic conditions. So a lot of big changes to HSAs proposed there. And interestingly, we, in addition, so when you look at this, when you look at all those proposals, it's no doubt that given his influence, some of those things made it into the Trump Care bill or the AHCA. So when we look at the two that made it in, the first is that the American Health Care Act would encourage the use of health FSAs by repealing the maximum contribution limit of $2,600 in 2017. So you could contribute presumably as much as you want or as much as the employer would allow, which is a great benefit. The AHC also wanted to encourage the use of HSAs by increasing the annual tax-free contribution limit, essentially almost doubling it to cover the deductible in the high deductible health plans. So you would be able under the AHCA to contribute $6,550 for self-coverage or $13,100 for family coverage in 2017. And there you can see what the current rates of contributions are, and you can see it's pretty much doubled there, so almost doubled there. So it's pretty amazing. Additionally, the AHCA would allow additional catch-up contributions of up to $1,000 by people over 55, and both spouses can make catch-up contributions to the same HSA. It would also expand what are qualified medical expenses to allow you to reimburse over-the-counter medications with your HSA, as well as expenses incurred up to 60 days prior to the date that the HSA was established. So great news there. And finally, some additional great news is that the AHCA would repeal the tax provision that had increased the penalty for non-qualified medical expense reimbursements. Originally it was increased from 10% to 20%, and this would take it back down to a penalty of 10%. So great news there for employers and plan sponsors looking to get an HSA. But of course, that is if the Trump Care bill gets passed. It is currently being reviewed by the Senate. It's up for a vote. Senator Mitch McConnell has said that they're going to try to put it to a vote before the July 4th recess. Obviously, we're watching that very closely, and at the end of this program, we're going to talk about some recent developments in that area. But it's something it's something that we're definitely watching very closely. Okay, so let's get started with the meat of today's presentation, which is talking about the basics, just a review of the basic rules that apply to consumer-driven health plans, the things that we think every HR department should know about, and are the important rules that are out there. And let's start with the Health FSA, the Health Flexible Spending Arrangement. This type of plan allows employees to set aside money from each paycheck pre-tax, and the main thing here, it can be used for any kind of medical expense, pay for any like dental, vision, deductibles, things like that. That are not paid for by insurance or any other arrangement. And the main distinguishing factor here, the thing that kind of makes it unique among the other types of CDHPs, is that it's always provided by an employer. So you can only get a health FSA through your employment. It is subject to certain per plan salary reduction maximum amounts. The maximum contribution is $2,600 for 2017, and that amount can be limited by the sponsor. The $2,600 is the maximum IRS amount that's permitted, and it's important to remember that it's per plan. So it's per plan year. So in other words, if your plan year expands goes into 2018, it's still at 2,600 contribution maximum. So it's something important to remember. And also, virtually all health FSAs are considered to be accepted benefits under the ACA. We'll talk more about that later, but it's a requirement under the ACA. We'll talk about all of these things in more detail on this slide, but just wanted to give you kind of an overview of all the different laws that apply to health FSAs, because it's pretty amazing when you look at it all. The first thing to note is that a health FSA is considered to be a self-insured medical reimbursement plan. So it's subject to sections 105, 106, and 213 of the code, and we'll talk about what that means later. It is a flexible spending arrangement. So it's subject to special rules, special Treasury rules that apply to those. It's also a group health plan, so it's subject to COBRA, the ACA, HIPAA, FMLA, other laws. It's an employee welfare benefit plan under ERISA. It's subject to ERISA, so you need to do that Form 5500 for it, right? It's also, like other cafeteria plan benefits, it's subject to Section 125 and state laws that may apply to it if they're not preempted by ERISA. So a lot of rules out there. The big ones really are, a lot of the big rules that for these are in code sections 105 and 106. They require that you have a written plan document for your health FSA, something that's not as often overlooked, particularly by smaller employers out there. You need to have your plan document for this. Also, as we talked about before, you can only use it for reimbursements for medical care as defined under Section 213D of the code. So also under the ACA, reimbursements are permitted for employees, spouses, and children who are under the age 27 as of the end of the taxable year, or tax dependents under federal law, as defined under federal law for health coverage purposes, which of course does not usually include domestic partners who are not tax dependents. Also under the ACA, medicines or drugs other than insulin have to be prescribed. You can't claim a tax deduction for the same expenses, and non-discrimination rules apply under Code Section 105H, just as they do for self-insured medical plans. And of course, there's a $2,600 limit per plan that we talked about before. That's not on the calendar year. Remember, it's on the plan year, unlike the dependent care assistance plan, which is another type of FSA. Now, there are special rules for health FSAs that are important to understand. One of the most important and unique rules that applies to health FSAs is called the Uniform Coverage Rule. And the easy way to explain this is that the Uniform Coverage Rule, it requires that the maximum amount of reimbursement from a health FSA be available at all times during the coverage period. So in other words, if typically you have a 12-month coverage period, a person should be able to take the full amount of that reimbursement amount on the first day of the coverage period, so long as they're making, monthly, so long as they're continuing to contribute. But it's one of those things that is often not taken into account. And the reason for that is because it's important that if you're administering this type of plan, that you don't just cut off an employee and say, you're only entitled to the amount of reimbursement that you've contributed in thus far. I mean, that would be a big mistake. You need to be able to allow them, kind of like any type of fixed insurance, it's kind of like any kind of insurance policy with a fixed premium. You have to allow them to take the full amount, assuming they continue to make their regular contributions. So there is also a use it or lose it rule. You use what you didn't, what you contributed. At the end of the year, there's some exceptions. There's a 2.5-month grace period, and carryovers are permitted up to $500 if the plan language in the plan document allows for that. Claims have to be incurred during the coverage period, with the exception of that you're allowed a run-out period. There also is a claim substantiation requirement. It can't be used to reimburse insurance premiums, and you can't use this to reimburse expenses that were reimbursed elsewhere. So let's now talk about the other type of FSA, the other major one that's out there that applies so much to so much of what we do here on a regular basis. We get so many questions about these types of plans. The Dependent Care Assistance Plan FSA, or DCAP. The main rules, the first thing to note, of course, is that a DCAP is an FSA, so it is subject to a lot of those same regulatory rules that apply for FSAs, other than the uniform coverage rule, it is not a group health plan. So unlike the health FSA, the DCAP is not a group health plan, not a welfare benefit plan. It's not subject to COBRA, HIPAA, and ERISA. However, there are other rules that are special to DCAPs, and those are under Code Section 129. Those require a written plan document for your DCAP. Also, it can only be used for qualifying dependent care assistance expenses. So you can use it for daycare, child care, dependent care, all that stuff's okay. However, you can't use it for overnight camp. That's an example of something you can't use it for. So you got to make sure that what you're doing is really truly a dependent care expense. The statutory contribution limits apply of generally $5,000 is the limit, and there are non-discrimination requirements under Code Section 129 that are different, separate and apart from the non-discrimination requirements of your cafeteria plan that you're using to make those pre-tax contributions to the DCAP. So a lot of things in there that are important to take into account. Now let's move on to HRAs, which are extremely common as well. These are medical expense reimbursement plans solely funded by the employer. So if you're in an HR department, let's say you haven't been doing enough training when an employee comes up to you and asks you what's the employee contribution to the HRA. So you got to be really communication is so important with these types of plans. You really want to make sure that your teams out there, your employees understand how these things work. But that's one of those things where that's a real basic thing about the HRA. Key characteristics are that it allows for the reimbursement of out-of-pocket medical expenses and certain insurance premiums that have not been reimbursed elsewhere. It can permit carryovers of unused dollar amounts from year to year, although that's typically not very common. It has to be offered. This is the ACA rule that we talked about that we'll go into more detail later, but it has to be offered in conjunction or integrated with an employer's major medical plan. And generally speaking, with some exceptions like the CUSERA or a standalone retiree HRA, also cannot be offered through a cafeteria plan. So, which makes sense. You're not making any, employees are not making pre-tax contributions to it. It's employer paid. The laws that apply are the code sections 105 and 106 that apply for medical reimbursement plans. There is actually no code section that's expressly dedicated to HRAs. So much of what we know about the rules and requirements for HRAs are through tax guidance. So the IRS has released a lot of guidance about how HRAs are supposed to be administered. But the main rules are you need a written plan document that has to be adopted by the employer. Under the ACA, reimbursement is permitted for the employee, the spouse, and employee's children who are under age 27 as of the end of the taxable year, or tax dependents for health coverage purposes. Usually you don't see domestic partners on the HRAs, although there's been informal guidance from the IRS saying that it is permitted, but it's very rare to see that. Under the ACA, medicines or drugs other than insulin have to be prescribed, and non-discrimination rules apply under Code Section 105H to your HRAs. There's additional rules as well. They are considered to be group health plans. That's something that's quite often overlooked. So, as well as there's ACA coverage mandates in there, and of course, as a group health plan, that means you have to comply with COBRA and HIPAA. Other rules that apply to group health plans, so it's not as simple. You also may be subject to the PHSA, which is a rule that applies to state or local governments. So a lot of rules that apply there, and there's others as well, right? We're just giving the basics here, but one thing that's commonly overlooked as well is under the ACA, you have to, it is a self-insured health plan, so you have to make a PCORI fee, payment for it, which is another thing that's often overlooked. So, this is kind of a big overview of all the primary HRA rules, right? Only employer contributions are permitted. We talked about that. The reimbursement is only for qualified expenses, so high deductible health plan deductibles, copays, other cost sharing. There's no cash out of unused amounts, but some spend downs are permitted. Very unusual to see that. It is eligible for continuation through COBRA, like we talked about. So unused amounts not used during the coverage period can be carried over, but depend on the terms of the employer's plan. There's no catch-up contributions permitted for HRAs. HRAs are self-insured plans, like we talked about. They have to comply with the PCORI rule, the PCORI fee, the non-discrimination testing for self-insured plans, and they have to be integrated with with those exceptions we talked about, the Coursera and the retiree plan. So a lot of information there. That's kind of the big picture. One question that we often get is, well, how do you calculate, right? You have to give COBRA for an HRA. So how do you calculate that COBRA premium? And it's the applicable premium, of course, the general rule under COBRA is that the applicable premium is equal to the total cost of coverage, including any related administrative fees, and the plan is permitted to charge a qualified beneficiary up to 102% of the applicable premium. Under IRS Notice 2002-45, an employer cannot base the COBRA premium on an employee's current account balance. So that makes things, of course, very difficult when you're trying to figure out what to charge for the HRA, how to calculate it for the HRAs. There are, however, two permitted methods for calculating the COBRA premium. The first is the past cost method, which allows you to, we're not going to go into all the details about these two methods, but generally speaking, on that first one, you can divide the HRA's total costs for the prior year by the total number of HRA participants, and you can get a certain number. And of course, you can't use that if it's your first year you're offering the HRA. So if that's the case, you would use this other method called the reasonable actuarial estimate method, where the premium has to be equal to a reasonable estimate of the cost of providing coverage for such period. Generally, that's determined on an actuarial basis. You would usually get an actuary to make that determination. So those are the two main methods that are used. One question that comes up a lot is, well, what about calculating imputed income for domestic partners? Because if you remember, we talked about this earlier. Domestic partners are not considered to be spouses. Same thing with civil union partners. Under federal law, they don't have the same rights as spouses under federal law, and are considered to be not considered to be spouses for federal tax law purposes. So if they're not a tax dependent under federal law, then an employer cannot make any kind of pre-tax contributions for these individuals, or when it comes to calculating what their imputed income is going to be, it's very difficult for HRAs. And while the Treasury has informally approved HRAs to reimburse expenses of non-tax dependent domestic partners, they allow this when the fair market value of the domestic partner's HRA coverage has been included in the participant's federal gross income. However, they didn't in that guidance they didn't give us any kind of approved methodology for determining what is fair market value, how do you calculate that. So it's very difficult to establish that the coverage has been fully taxed. So before so it's something you definitely want to consult with a trusted advisor, a tax accountant, and make sure that you're doing that correctly and that it's being done on the same basis for all employees that are in that situation. The other thing to take into account, of course, is that before you make that decision to extend HRA coverage to a non-tax dependent, like a domestic partner or a civil union, you really want to take a look at your plan document, right, and make sure that it defines what are eligible domestic partners or civil union partners. For domestic partners, for example, there really is no uniform definition. Generally it's meant to mean an unmarried adult who has a close personal and financially interdependent relationship with the employee, but it's something that comes up a lot when you see dependent audits done by plans. So what does that mean? The considerations when you're putting your plan document together, you really want to be careful about how you're defining eligibility for your HRA. Generally speaking, you see issues where problems happen where people share a residency. So you see roommates, for example, people who are completely unrelated, who are not really, in fact, domestic partners or civil union partners, getting onto the HRAs. So you really want to make sure that you document how what the relationship is, that you ask for documentation about that, and of course that you administer that in the same way for all employees. So just because you may know that some people are domestic partners or in a certain relationship, you don't just ask them to provide supporting documentation. You ask everybody who's claiming that for the supporting documentation. Okay, so now let's go on to the most fun part of our presentation, which is HSAs. As you know, the most popular part right now by our government. HSAs are tax-favored, individually owned accounts for out-of-pocket health and medical expenses. So these are really accounts like IRAs for your health. They are completely independent, not tied to your employer, so you can take them with you when you go from employer to employer. The three main tax breaks for these are contributions are tax-free, income growth is tax-free, and distributions for qualified expenses are tax-free. So very, very favorable plan. They have to be offered in conjunction with a high-deductible health plan, and they have to have certain designated minimum annual deductibles and maximum out-of-pockets, or MADs and MOOPs. And that's an area where we see a lot of problems and issues. People get confused by that. We're going to go into that in a little bit more detail. Now, the statutory rules governing HSAs are primarily found in Section 223 of the Code. So unlike HRAs, these are typically paid for on a pre-tax basis through a cafeteria plan. So most of these are so for most of these types of plans, the Section 125 rules also apply. And it's important, the big distinction, the thing that makes them different from the other two, is that these are not group health plans, so they are not subject to COBRA. So just because you have to stop contributing to an HSA doesn't mean you get any kind of COBRA benefit, which makes sense. Some of the primary rules here are that both employers and employees can contribute. Distributions for qualified medical expenses are tax-free, but non-medical distributions are taxable, with an exception for those that are 65 or older. It's available to all employees that have high-deductible health coverage, including owners and partners, but not on a pre-tax basis. The following are eligible for HSA contributions. So if you're an individual that's covered by a high-deductible health plan, if you're not covered by other health insurance, including the FSA of a spouse, if you're not enrolled in Medicare, and the key thing is that even if you're eligible for Medicare, there's a distinction there. If you're eligible for Medicare, you can still contribute to HSAs. It's only once you become enrolled in Medicare that you are prohibited from contributing to the HSA. Also, you cannot be claimed as a dependent on someone else's tax return. That's another key requirement. Some other requirements: children cannot establish their own HSAs. Spouses and domestic partners can establish their own HSAs if they're eligible. There's no income limits on who can contribute to an HSA, and employees over age 65 can contribute so long as they're not enrolled in any, in Medicare Part A, B, C, or D, as we talked about before. So what happens when your HSA eligibility ends? Well, you cease to be an HSA eligible individual because, let's say, you enroll in Medicare, or you have other impermissible non-high deductible health plan coverage. You can still receive those tax-free HSA distributions for the qualified medical expenses from your HSA, or you can even still withdraw the funds on a taxable basis, but you can no longer make HSA contributions or have them made on your behalf by your employer, for example, on a tax-favored basis beginning once the eligibility ends. So important thing to think about. When it comes to distributions, there are no legal restrictions on when HSA distributions can be made. The HSA holder is entitled to them for any purpose, and only the HSA holder can determine how the distributions will be used. There is also some IRS guidance out there about debit cards and some of the restrictions about how to use them. And that's out there. We're not going to go into a lot of detail about that today, but there's a lot of rules out there that we can always help you out with if you have questions. And just as a helpful resource for you, we've created this helpful comparison matrix, a comparison chart that kind of gives you a good overview of a lot of the rules we've talked about today and that we'll continue to talk about. Sort of as a brief synopsis, a brief summary of that chart, some of the obvious differences between these plans, as you probably know from just everything we talked about, are that there's very different eligibility, availability rules, different contribution amounts, different rules for funding and ownership. But some of the not so obvious differences deal with the stacking of plans, and we're going to talk a little bit about that later. Essentially, you can't have certain types of FSAs with HSAs, things like that. There's also the application of COBRA rules also really trips people up out there. They get confused about, well, why can't I use COBRA with my HSA and I can use it with the health FSA? And also there's special rules for the application of COBRA to health FSAs to make it even more confusing for people. So, we're not going to go into all of that detail today, but it's something that you should be taking into account. And then, of course, the non-discrimination rules get confusing for folks. We'll take a brief look at that today, but it's just another area of confusion. And, of course, the deferring requirements for these plans under the ACA cause confusion. And we'll talk about that later. So what are the primary HSA rules? Well, if the employer makes HSA contributions outside of a cafeteria plan, it's subject to a 35% excise tax on its contributions for a calendar year, unless it makes comparable contributions. So the comparability rule is really, effectively it operates like a non-discrimination rule for employers, but in reality it's very rarely used because most of these plans are offered through employers are not making post-tax contributions to these plans. These are all offered, for the most part, 99.99% are offered through cafeteria plans. But just to give an overview of that rule, comparable contributions are contributions to each HSA account of an employer which are the same dollar amount or which are the same percentage of the annual deductible. So if you do that, generally speaking, you're going to be okay. We're not going to go into a lot more detail on that because it's so similar to other non-discrimination rules, including the non-discrimination rules for Section 125 plans. Again, we're not going to go into a lot of detail here, but this is more of sort of a helpful resource slide for you that kind of gives an overview of how the non-discrimination tests work for Section 125. But the big two components here, if you have to boil all this down, there's two main requirements. The plan, generally speaking, has to have the same eligibility for highly compensated employees as for non-highly compensated employees, and it has to have the same benefits availability and utilization for highly comped versus non-highly comped. So the key area where people get tripped up, where problems can happen, is utilization, because employers have no control over that, right? Utilization refers to the fact you may have a highly compensated person who's taking a lot more of the benefit, using it much more than everybody else, and that can result in failing the non-discrimination testing and a tax impact for that employee. In many cases, employers will have to either gross up that employee's compensation or change the plan around to fix that. It's something we can help you out with, but in most cases, most employers typically use FSA vendors or actuaries to complete this non-discrimination testing on an annual basis under Section 125. And of course, it's important to understand that the Section 125 just applies to the cafeteria plan or the vehicle for these consumer-driven plans. You also have to do testing for component parts of the cafeteria plan, as well as other consumer-driven health plans like DCAPs, HSAs, HRAs, and FSAs. So it's not enough just to say you did Section 125 testing. You've got to do all those component parts. There's also some very interesting rules that apply for HSAs when it comes to coordinating with Medicare. So if like we talked about before, the key rule there, of course, is that once you're enrolled in any part of Medicare, those main parts of Medicare, Part A, for example, then you lose your ability to contribute to the HSA. The other important thing to note there is that if an employee enrolls in Social Security, then that employee will automatically be enrolled in Medicare Part A. So enrolling in Social Security means you're no longer eligible to contribute to the HSA. And we're not going to go into all these other rules here, but this is really just more for your own reference as a resource for you. And obviously that we could do a whole presentation on just that one slide. Okay, some other common HSA issues comes about with regard to stacking. Here, this is commonly misunderstood, but you're not allowed. The general rule here is that you're not allowed to have a general purpose health FSA or HRA and offer employees the opportunity to make HSA contributions. So if you want to offer an HSA contribution arrangement, it has to be done with one of the alternative designs that's permitted for health FSAs and HRAs. Those are, that list there, limited purpose health FSAs and HRAs, suspended HRAs, high deductible health plans coupled with a post-deductible health FSA or HRA, or a retirement HRA. We most commonly see that third bullet one. So generally speaking, most employers use the post-deductible health FSA in combination with that HSA contribution arrangement, so they can do both. But it really depends on the employer. We're not going to talk about each of those types of limited purpose designs, but you can always ask us later if you have questions about them. Spousal, domestic partner, and dependent issues, like we talked about earlier with the HRA, are still very common problems for people to understand with the HSAs. And again, we're not going to go into a lot of detail with that, but it kind of makes sense, right, why that's so confusing for folks. And then finally, the third area where we see the most misunderstandings deal with the maximum out-of-pockets and the minimum annual deductibles. If you mess that part up, if you get the wrong minimum annual deductible or you have a wrong individual embedded deductible in your high deductible health plan, that can result in losing the qualified status of the high deductible health plan, and essentially meaning that the HSA contributions that you thought were going to be pre-tax become taxable, and it may require correction. And if it's from a prior year, you have to correct the W-2. Even though there's a lot of things that are required there, it is relatively common for that to happen. So it's not the end of the world if it does happen, but it does require correction. And of course, eligibility issues are a big problem we see out there with high deductible health plans. And we just also wanted to briefly end the section about the basics by talking a little bit about the Affordable Care Act and why the rules are so important. And the main thing here is that the penalties are high, right? I mean, that's the main reason why it's such an important thing to understand. If you're doing the wrong kind of plan, especially when it comes to HRAs, if you're improperly doing your HRA, the penalties can be $100 a day per participant. So the penalties are very, very high. And since 2010, we've seen the agencies that have been implementing and administering the Affordable Care Act create this very complicated maze of regulatory hurdles for CDHPs. Just take a look at IRS Notice 2015-87, which really changed a lot of the ways that employers can implement and design their consumer-driven health plans. So a lot of rules there. Of course, that's a whole separate presentation that we could do. But we are going to focus a little bit more on the HRAs and the penalties that are there. And of course, like we talked about in the beginning, the new president and Congress are really trying to see if they can expand consumer-driven health plans. So even with all the rules we talked about today, in the very near future, they could be different again. So just because they want to do things to make them more flexible. Okay, so let's talk about integrated HRAs, because this is where, especially with smaller companies and smaller employers, we see the most problems. Essentially, when the Affordable Care Act came along, it said standalone HRAs are dead, with the exception of retiree-only arrangements and CUSERAs. And in order to be an integrated HRA and to be okay, you have to require enrollment in both the HRA and the group health plan. HRA cannot be used to purchase individual coverage, whether in the individual market or on the exchanges. Also, there are some things you can do. You can limit HRAs to only accepted benefits. There's some flexibility in there. You can continue to use HRAs once participation in the underlying health plan ends. But for the most part, even with all of that stuff, you really have to make sure that HRA is integrated. If it's not, then there's some big penalties that could result, and we'll talk about that a little bit later. Now, for health FSAs, they're only considered to be exempt from the ACA mandates if they're considered to be accepted benefits, which means that it has to be offered also in conjunction with the health plan and limit employer contributions to $500. So essentially every health FSA, however, today is considered to be an accepted benefit. So it's very rare to see that not be the case. But what happens if you get this wrong, right? What happens if you have an HRA and you're using it to reimburse individual to reimburse premiums for individuals or the cost of individual health insurance coverage? Well, then there's very big penalties that can result of $100 per day per participant with a cap of $500,000 per year per entity. It'll be called an employer payment plan that does not satisfy the ACA mandate. So big problems out there. Of course, we talked about CUSERAs can be used to get rid of that problem, or a standalone retiree-only plan, retiree-only HRA. So we do have some options out there to do things differently, but you could offer only accepted benefits. You could increase taxable compensation to help people pay for individual coverage if you don't want to deal with all of these complicated rules for HRAs. But you really have to be careful when you're out there. Another just final word of caution out there is that when you're looking at your HRA, you have to take into account the whole control group, right? Because just because you think you're in compliance with these HRA rules, there may be another entity that has a different broker, a different advisor, or a different attorney, and they're not doing things correctly. They're reimbursing individual premiums, and they could impose liability on your organization. Another common thing that we see out there is that another area of caution is that you could be reimbursing, things that you think are okay to reimburse, like eyeglasses or certain, medical, certain eye services that could be technically considered a medical expense reimbursement plan and have to comply with these requirements, like plan doc requirements and everything else. So always important to have your plan document reviewed by a competent advisor or attorney who can take a look at that and make sure that you're in compliance with that. Okay, we briefly wanted to talk about, before we close today, some of the things that are happening with the Repeal and Replace initiative with the Affordable Care Act. And of course, we're not going to have time today to go into all the details about that, which is why I have a quick plug for our ACA Now webpage. If you go to corpsin.com/ACA Now, you will be able to see a play-by-play of everything that's happening with the changes to the Affordable Care Act. Of course, most notably, recently we saw that the House passed the bill on May 4th. It's being considered by the Senate, and we should know by July 4th if it will be passed by the Senate and go onto the President's desk, and we're all watching that very closely over here. And then finally, before we leave today, we wanted to also talk about some other compliance developments that are significant for employers. On March 22nd, the House passed the Small Business Health Fairness Act, which makes it easier for small employers to join into association health plans. Of course, it's still not final law yet, but we're watching that closely. The House also passed the Self-Insurance Protection Act on April 5th of 2017, and that bill takes a self-insured stop-loss policy out of the definition of health insurance, which makes it more insulated and protected from competing federal legislation that could put additional requirements on your stop-loss policy. In plain English, it just means it's going to make it easier for you to go self-insured. Also, still we're watching that closely. It's not a law yet. On April 5th, we also saw this very big historic settlement happen under the ADA. The reason why that's so significant is because, as you probably know, the EEOC released new wellness plan rules last summer, and we haven't really seen much resolution there in the case law, and so this kind of shows you what can go wrong if you don't do it correctly. In this case, an employer was required to pay $100,000 to an employee and do workplace training, among other requirements, because they didn't do it correctly. And what happened here, generally speaking, is that the employer said if you don't do a biometric testing under our wellness plan, you employees will have to pay the full cost of the premium for our self-insured plan. One of the employees didn't want to do that, and she alleged that the employer retaliated against her. It was going through the court system before the settlement. And of course, more than that $100,000 payment, of course, you have to take into account the fact that those lawyers probably cost a lot of money, and just the reputational damage to this company were probably very significant. Also, on April 24th, we saw a very large settlement between HHS and a wireless health services provider. A $2.5 million penalty was assessed against that provider for, in that case, an unencrypted laptop was stolen, and the employer lost a significant amount of EPHI. All the more reason for why it's important to have good systems in place to cut off that information in that event, or to have, it's always important to have very good policies and procedures in place and to do training on that, which is a service that we, of course, can help you with here at Corporate Synergies. And then on May 12th, we saw another CCAM, much like the one we saw. In many ways, it was kind of like a part two of the one that we talked about at the beginning of today's presentation. This one was addressing the taxation of these special new hybrid wellness plan / fixed indemnity plan arrangements that are being promoted out there by some producers on the market. The selling pitch here is that you can give as much money as you want tax-free through this wellness plan, which is a great thing, of course, but the IRS does not view it that way. When you look at these types of plans, they see that those payments are taxable compensation. And so this really closes the door on those new types of hybrid plans that were being offered. And most significantly, for purposes of what we do here, I think one of the most significant things that happened, although it really only affects a narrow category of employers, is that on June 5th, quite recently, the Supreme Court expanded the church plan exemption under ERISA in a case involving pension plans. It expanded that exception to church-affiliated employers. So, very interesting decision, essentially just saying that even if the plan, in this case, in the case it was a pension plan, but the decision applies to both pension and health plans, but in that case, in a unanimous Supreme Court decision, they said that even if the plan was not established by a church, but even if it was just established by a church-affiliated organization, in both cases, both the church and the church-affiliated organization can claim an exemption from ERISA. So, very interesting news. We would not advise every single church-affiliated employer in the country to just say, hey, let's stop updating and amending our plan doc. Obviously, it's something to watch closely. We could see Congress write some new laws in that area to to memorialize that decision. It's definitely something we're watching very closely, and we'll be continuing to advise our clients on. So that's the big picture. We want to thank you for joining us today, and here's some information about your HR credits. Thank you.
Great information, Dan. Thank you. As a reminder, all participants will be emailed the presentation slides by tomorrow. Your SHRM PDC and HRCI credits can be downloaded now by clicking the yellow document icon to the right of the widget bar on the bottom of your screen. As you exit the webinar, please take a moment to complete the brief questionnaire that appears so we can address any feedback you may have for us. Any further questions can be sent to ashley.whelan@corpsyn.com. That's ASHLEE.WHELAN@CORPSYN.com. Thanks for your attention, and please enjoy the rest of your day.